Hi there, Andrew Kalita from On Demand HR here with an important update regarding casual employment for business owners. The topic of casual employment has been brought to the forefront in recent years through decisions in the cases of Unpack versus Scheme and Unpack versus Rossato. In this short video, we're going to unpack these rulings as well as the result of the recent appeal. Changes implemented into the Fair Work Act to limit the initial scope of the precedent, as well as the implications and recommendations for businesses to undertake their workplace relations affairs in response to all of this and to maintain compliance. Both these significant cases against the same labour hire company, Unpack, ended up with rulings that determined that both employees who were engaged as casual employees were in practice full-time employees due to the regular and systematic nature of the work that they carried out. This led to a ruling that the employees were entitled to back pay of entitlements such as leave. However, the most significant outcome was that in determining the amount owing to the employees, the federal court did not consider the casual loading that was already paid to the employees as offsetting the leave entitlements owing. This means that hypothetically, if the employee was being paid $100 per hour plus a $25 per hour casual loading, the High Court considered that their base rate of pay was in effect $125 per hour, and the respondent was ordered to back pay entitlements based on this higher rate, and the additional $25 was not considered to offset the amount owing. Now, no doubt you can see why this caused significant fear in the business community, with concerns about massive payouts of entitlements across the entire spectrum of the economy. The federal government, in response, as part of the Fair Work Amendment supporting Australia's Job and Economic Recovery Bill 2021, in response to the COVID-19 pandemic, sought to firm up the definition of a casual employee to effectively close this potential loophole and to provide certainty to businesses. Most notably, under Section 15A of the Act, they define casual employment as where an offer of employment is made by the employer on the basis that the employer makes no firm advance commitment to continuing and indefinite work according to an agreed pattern of work for the person, and the offer is accepted on that basis, resulting in the person becoming an employee. In effect, what this means is that the test of casual employment is made at the time of offering the employment and cannot change during the course of employment based on working patterns or other factors unless it's mutually agreed between the employer and the employee. So even further provisions were introduced with the effect of allowing employers to offset any casual loading already paid against entitlements in the event future orders are given against the employer. The legislative changes have recently led to the case of Unpack versus Rossato to be overturned, and under the new regulations, Rossato was considered a casual employee by the new definition. Now, with all of this in the history books, it seems like a win for employers engaging casual staff, as well as a win for employees protecting the higher take-home wages from the 25% casual loading rates. So the question remains, what should businesses do to protect themselves? We have a couple of recommendations for our clients, including using the opportunity to review their employment contracts with an emphasis on clearly identifying the nature of employment as a casual employee, as well as identifying the inclusion of a casual loading. The inclusion of preventative clauses in employment contracts to offset casual loading paid against any other employee entitlements which may be owing in the future. Reviewing their compliance with the National Employment Standards, where an additional provision has recently been introduced providing for an obligation to offer casual conversion after 12 months. Often it is good practice to include this in the initial offer of employment to prevent compliance concerns in the future. Now, we note that once employees discover that they'll actually be earning less take-home pay by converting to part-time or full-time employment, in many cases, they choose to remain as casual employees despite what you might hear in the media. So if you'd like some assistance in determining if your business has any compliance risks regarding casual employees or any other area of your workplace relations affairs, please reach out to us by visiting ondemandhr.com.au and we'll be only too happy to help. So once again, my name is Andrew Kalita from On Demand HR and looking forward to seeing you all in the next update.